Welcome back to the course, Protecting the Legal Rights of Artists and Designers. I'm Jonathan Politi, and we are working our way through materials covering the legal system and dispute resolution. In this segment, we'll be covering sources of law and generally where the law comes from and how it is created. Sources of law, where the laws come from. Everything starts with the U.S. Constitution as a source of law. So the Constitution establishes our federal system of government, and it's the founding document that creates that basis. It provides for governmental structure, and it gives specific powers to the national government coming from the states, and it creates three branches of government: the legislative, the executive, and judicial branches. The Constitution describes the powers of each branch and the framework of the U.S. government, and it creates relationships between the federal and state governments. Again, with powers coming from the states and being given to the federal government, with any powers not delegated to the federal government remaining with the states. And it establishes the rights of U.S. citizens as they relate to the U.S. government. So, the Constitution sets up the structure and both empowers and limits the federal government. Now, state governments also have their own constitutions and their own state governments that are similar in structure to the federal government, with courts, legislatures, executive branches, that's the governors, and state agencies. The source of the state law comes from their constitutions. They're similar, but each state is unique. And everything is tied together with the U.S. Constitution being the highest law of the land. The U.S. Constitution has amendments, 27 so far. The first 10 are called the Bill of Rights, and they provide for rights of individuals. You've probably heard of the First Amendment, which provides the basis for freedoms of religion, freedom of speech, freedom of the press, freedom of assembly, and the right to petition the government. Or you've heard of the Fifth Amendment, the one that you hear on TV with those Miranda warnings that the police are supposed to give before interrogations, where individuals have the right not to speak in order not to incriminate themselves. But there are other rights that are provided in that amendment, setting out the rules for indictment by grand juries, eminent domain, when the government can take land from individuals and provide compensation, the right to due process of law so that people are treated fairly and afforded protections under the law, and prohibition of double jeopardy, so people cannot be tried twice for the same criminal offenses. There hasn't been a new amendment to the Constitution in a while, but pay attention. The ERA, or Equal Rights Amendment, is still in play and was just recently ratified by Virginia and could potentially be passed if Congress changes some deadlines and accepts it. So that's equal rights for women guaranteed in the Constitution. So for sources of law, other than the U.S. Constitution, the three branches of government can create laws. The legislative branch, the executive branch, that's the president, and the judicial branch, the Supreme Court and other federal appellate and circuit courts that are beneath it. These three branches of government are where laws are created, or so they say. So, three branches of government, okay. I say that there are four branches of government. Four branches of government being the legislative branch, the executive branch, the judicial branch, and government agencies. Government agencies being the fourth branch of government. The legislature can create laws known as statutes. The executive branch can create and issue executive orders and make treaties with governments. The judicial branch can interpret the law and create case law precedents through its decisions, also known as common law. And agencies can create rules and regulations known as regulatory law in the areas of law that fall within the scope of their powers. All right, so let's get into these different types of laws. Executive orders. From the executive branch, executive orders. Now, although there is no specific grant of power creating executive orders in the Constitution, Article 2 of the Constitution has been interpreted to allow the President to exercise executive power and thus issue orders that have the force and effect of law. As far as keeping those orders in check, the U.S. Supreme Court has the power to review and to overturn those orders. And for the most part, they have found that those orders are legal and enforceable. Congress doesn't have the power to check the authority of presidential orders, but because Congress has what's known as the power of the purse, because it controls funding, it can hollow out executive orders by not funding them. Without any gas, the car isn't going anywhere. All right, examples of executive orders for racial discrimination. Back in the 1960s, Presidents John F. Kennedy and Lyndon Johnson both issued orders for equality in federal housing, in hiring, and in contracting. And President Ronald Reagan, another example, he issued an order in 1984 barring the use of federal funds for use to advocate for abortion. And President Bill Clinton used an executive order to reverse that order when he took office later. And President Barack Obama used executive orders to halt deportation of thousands of immigrants who were brought to the U.S. as children. All of these are previous examples. With the current presidency, pay attention, see how something like this affects you. Right now, TikTok and WeChat are currently being considered for an executive order banning them due to national security concerns. Follow this in the news and you'll see how laws like this can apply. Next, from the legislative branch, there's the process by which statutory laws are created. I have here a flow chart as to the process for how laws are proposed and then make their way as bills through both houses of Congress, eventually to be signed and ratified by the President, or vetoed by the President as part of that process. I have here a reference to Schoolhouse Rock, which was an old favorite of Saturday morning cartoons and provided civics lessons to song and music. I can't play it here, but I am including a link for you to the YouTube video if you wish to see it. And it's kind of cute and it's memorable, and it does probably a better job than I'm going to do explaining how a bill becomes a law. Yeah, there's the link. That brings us to government agencies and regulatory laws. I have said before that government agencies have magical powers. It's because they have the powers of all three branches of government. They have legislative, executive, and judicial powers in a manner of speaking. Administrative agencies have rulemaking power, the ability to create regulatory laws. They have enforcement functions to investigate and prosecute. And they have adjudicatory power. They can hold hearings to review violations and issue rulings. So it's legislative like Congress, executive like the presidency, and judicial like the courts. Unlike other branches of government that have checks and balances on each other and separation of powers between the branches, government agencies have all three combined. That potentially can be problematic. However, the agencies are overseen by Congress, the courts, and the executive branch, and they're supposed to be walling off where the different divisions within an agency are not supposed to communicate amongst themselves. But they are subject to the policies and agendas of whomever's in power in the branches of government, so it's good to be aware of who is in power and how that will affect your business. What policies will be protected and promoted, and what will be punished. Focusing on the rulemaking function, regulations are created by agencies to further their mission of the agency, as far as those rules and regulations fall within the scope of the mandate that created that agency. Agencies are limited in the authority to the areas of law that they were created to deal with. The law that creates them, the Enabling Act, is what empowers an agency and also limits it. The process of rulemaking is done in stages and is open to the public. Rather than being made behind closed doors, rules are meant to be transparent and participatory. The people are meant to be part of the process. It's controlled by a law called the Administrative Procedures Act, or APA, which defines the process of how rules and regulations are created. Alright, so this is a good visual of the process from reginfo.gov, and it is free for you to download. I will include a link for you, and I like how this is set up. It shows 9 steps in the process of rulemaking, but I want to simplify it a little for our purposes. So in the first 2 steps, that's the creation phase, where ideas are proposed and the agency decides if there should be new regulation, what it should be, if it is needed, and how it would apply. That then takes us to the next 4 stages to go through the process of defining a potential rule and presenting it for review. What is known as the notice and comment phases. During that process, the public can provide feedback and suggestions for the agency to consider. The agency can review the comments and modify or amend the proposed rule, and it can cycle back through the process for additional notice and commentary. And this can continue until the proposed rule gets rejected, or until the agency determines that no further changes are necessary and a final rule is reviewed and given force and effect. It's approved. Regulation of business is carried out mostly by government agencies, so it's good to understand the process if a business wants to participate and how the law is shaped in the rulemaking process. And that brings us to common law, or court-made law. Courts have the ability to make new law in deciding court cases if no other law on the matter at hand exists. No statute, no executive order, no regulation. In the absence of something else, a court can create law using its powers. If a law does exist already, then the courts are to follow the law and interpret it to apply to the specific facts of the case that wind up before them. The concept of precedent provides direction on how courts are to consistently decide cases. If a case has been decided previously by a higher court, an appeals court, within that jurisdiction, then the lower courts are supposed to look to those previously decided cases and follow the decision of the higher court. So, when a plaintiff files a lawsuit in a trial court, the parties in the court can rely upon previous decisions to define how the present case should be decided. They can look to previous cases to determine and decide. Understand that just because a law is in place does not mean that it has to remain that way. Many times, parties will file a lawsuit to challenge and ultimately overturn precedent. Sometimes the values of society can change, and the courts can play a role in helping to change the existing law. The court can be a method for stirring up and settling the issues that confront parties. It's a good chart that shows how the government is established under the Constitution. You have the 3 branches of government, and then you have all the government agencies, and then you have the government agencies that work under the different branches of the government. That brings us to the hierarchy of laws when there's a conflict between 2 different levels of laws. So you have constitutional law, statutory law, executive orders, regulatory law, and at the bottom, case law. Should there be a conflict between 2 laws, one of the things that a court can consider is the level of authority in the hierarchy of laws, depending on where and how the law was created, and the type and source of law that would control. So if there's a regulation created by an agency and a statute created by Congress that conflict in some area, According to this convention, the statute has more weight and authority, and it becomes the controlling law. If there's a conflict between an executive order and a constitutional right, the constitutional right becomes the controlling law. When it comes to conflict of laws, the higher up the hierarchy you go, the more powerful the law. Laws at higher levels supersede laws at a lower level. The higher up the hierarchy, the more powerful the law. It should also be stated that state laws and federal laws can also conflict from time to time. When that happens, the general rule is that federal law is the controlling law. Same idea here. As you work your way up the hierarchy, more powerful, the higher up you go. Now, no law is invincible, and it's possible to use the courts to change or invalidate laws. So, as stated before, lawsuits can be filed to challenge and overturn, quote, bad laws. Okay, that winds up sources of laws and how they can be created, and we will cover court structure next in the next video.